Here to Trump in the courtroom coverage here on Brooklyn News. It is 8:40 in the morning. Trump in the courtroom coverage starts right now. Today, inside courtroom 1530, jurors will hear their instructions from Justice Juan Merchan, the judge presiding over this case. And I'll summarize, or at least attempt to summarize, the closing arguments from the defense and the prosecution made to the jurors as deliberation is expected to begin today. Okay. Also, yesterday, Robert De Niro spoke outside the courtroom as a Biden campaign surrogate. Also, UP says it wasn't just him, but also there was a January 6th Capitol police officer that worked there at the time. So, a lot coming up, but thanks for joining me. I'm Jackson Mitchell. We are just 30 minutes away from the trial in which the people of the state of New York accused the former president of the United States, Donald Trump, of 34 counts of falsifying business records, as they also claim he did so in order to influence the 2016 election. I'm watching tons of reporters that are inside the courtroom in order to give you minute by minute, or really second by second, of what's going on inside that courtroom. We're also going through a timeline and viewing other news stories from different perspectives as we get started in Brooklyn News' live coverage of Trump in the courtroom. We are waiting for Trump to arrive at the courtroom and speak to the media. I believe we're only going to have audio only, it looks like, because this feed is very choppy. You can see his motorcade passing by there, so we will do our best with what we have, though. Just thankful that we can be here. Okay, so we're waiting for that, and that should happen any moment now. So as we wait for that, I believe we can show you, I believe we have it, where the Biden campaign spoke yesterday. If you'll stand by with me. Yeah, we do have it. Okay, here is the Biden campaign, or really, I believe it's just Robert De Niro. Just a piece of him speaking for about 3 minutes here. Yesterday outside the courthouse, and I'm not sure if he was inside the courthouse at any time. I do not believe so. But take a look.
I mean, this is really, even these people over here are it's kind of crazy. It's really crazy, and this thing, Donald Trump has created this. He should be telling them not to do this, but he's just, he wants to sow total, he wants to sow total chaos, which he's succeeding in some areas and places to do. Anyway, beside all that, this is my neighborhood, downtown New York City. I grew up here and feel at home in these streets. I feel comfortable. The Twin Towers fell just over here, just over there. This part of the city was like a ghost town. But we vowed we would not allow terrorists to change our way of life. And we started the Tribeca Festival to bring people back. I love this city. I love this city. I don't want to destroy it. Donald Trump wants to destroy not only the city, but the country, and eventually he could destroy the world. But we vowed we would not allow terrorists. I owe this city a lot. And that's why it's so weird that Donald Trump is just across the street. Because he doesn't belong in my city. I don't know where he belongs, but he certainly doesn't belong here. We New Yorkers used to tolerate him when he was just another grubby real estate hustler masquerading as a big shot, a two-bit playboy lying his way into the tabloids, pretending to be a spokesperson for himself. He was calling it as himself for himself, to fool the press into inflating his net worth. A clown. But this city is pretty accommodating. We make room for clowns. We have them all over the city. People who do crazy things in the street, we tolerate it. It's part of the city, it's part of the culture. But not a person like Trump who will eventually run the country. That does not work, and we all know that. Anyway, we make room for clowns, to each his own. But no one takes him or took him really seriously. They take him seriously now, of course. But around the country, people who didn't know him as we did started to support him. They bought into his bullshit. Trump bought their votes with outrageous lies and empty promises. He got the most religious evangelicals to applaud a sinner who bragged about sexual assault, and who, just a couple of blocks from here, a jury found him liable for sexual abuse. Somehow he even got self-styled patriots to support a man who called for terminating the Constitution, and on January 6th rallied an angry mob to threaten democracy.
Okay, that was Robert. That was Robert De Niro speaking yesterday as a Biden campaign surrogate there at the courthouse. But today we have an interesting day ahead of us, because today is not just a day like normal when we hear testimony and different things of that nature. And I know yesterday we heard closing arguments. We're going to be summarizing that later in the stream here. And we're also going to be watching the courthouse, I do believe so. But if we take you over to, we'll watch that feed there, but I want to take you over to something else here. I just have to get this graphic ready. Sorry, a lot of different things to go through here. I believe it is 25, okay. 1 moment. Today is not just a day like normal. We are now to the part where the jury, you see there on your screen, that is the jurors, the 12 jurors, they decide and will decide if the the former president of the United States, is he guilty, is he not guilty? That's what we will be hearing. And that is what's important. That's what's happening today. I'm sure we will be flashing that graphic throughout this whole time, continuing there to watch inside the courtroom where any moment now we are expected to hear from the former president of the United States once he arrives. Now, we do know after a long day in court yesterday from closing arguments, he did not speak to the press. After, if he does today, we don't know. We're watching for it, though. Some other things in this first little while, before we kind of get through everything here, I want to take you through kind of what the jurors have to work with to decide if Mr. Trump is guilty or not guilty. The judge will be giving the jury instructions, which will be waiting for that to be added to the docket. So I can read to you that and analyze the instructions. But first, here's a few documents that are presented by the prosecution showing checks and different filings. Here, I'll pull those up for you guys. Something we've been talking about throughout this whole time. But we have those checks there at the bottom of your screen, where it says there's a retainer agreement. And you can even see in this one, if you look over on the right side of that page, towards the bottom here, where it says account 51 something, legal expense $35,000. That's what we are talking about right there. But I want to take you through some key dates here and some information, and it kind of just develops this case. It develops kind of how everything happened and how we are here today. So I'll start with, and I don't believe we can pull this up for you guys, but this is via ABC News. So let's start by reading this. In August of 2015, Trump meets with David Pecker, then chairman and CEO of American Media Incorporated, often referred to as AMI, which owns the National Enquirer at Trump Tower in New York. Pecker agrees to help with Trump's campaign by looking out for negative stories about him to, quote, catch and kill, according to prosecutor's statement of facts. He also agrees to publish negative stories about Trump's competitors in this election. By October and November of 2015 here, and let me check for any updates coming from the courtroom before we get to. Okay, continuing, but now we're on to October, November of 2015. Pecker learns that a former Trump Tower doorman was trying to sell information that Trump's allegedly fathered a child out of wedlock. AMI negotiates and signs an agreement to pay the doorman $30,000 in exchange for acquiring exclusive rights to the story. AMI later determines the story was not true and wanted to release the doorman from agreement, but lawyer A, which we have now learned is Michael Cohen, a Trump Organization lawyer believed to be Michael Cohen, I've just said that there, allegedly instructs him not to do so until after the presidential election, according to the statement of facts. By June 2016, the National Enquirer's editor-in-chief and chief content officer contacted Michael Cohen about a woman who is believed to be a Playboy model known as Karen McDougal, who allegedly said she had a sexual relationship with Trump while he was married, according to the statement of facts there. Cohen is updated by the National Enquirer about this regularly over text and by phone, according to the statement of facts there. Trump allegedly did not want this information to become public because he was concerned what impact it may have on his campaign for president, according to the statement of facts. AMI ultimately pays the woman $150,000 in exchange for her not speaking out on the alleged sexual relationship. She would also get 2 magazine cover features and a series of articles published under her byline. Prosecutors allege that this deal was made based on the understanding that Trump Organization would reimburse AMI for the payment. Now, something else to note here is in the defense's closing arguments, they said that this was normal, that the press often received payments to cover up or post fake stories and things of that nature. And God, I hope that's not true. Pecker consulted AMI's general counsel, and then told Cohen that the deal was on. That was the deal for $150,000 in exchange for Playboy model Karen McDougal to not speak out. By October 7th, 2016, that's when the Access Hollywood tape came out. According to prosecutors, evidence shows that both Trump and his campaign staff were concerned about the tape, and they thought that it would harm his ability as a candidate and reduce his standing with female voters in particular. By October 10th, 2016, AMI's editor-in-chief contacts Pecker about a second woman, believed to be adult film actress Stormy Daniels, who alleged she had a sexual encounter with Trump while he was married. Pecker tells the editor-in-chief to notify Cohen. The AMI editor-in-chief contacts Cohen with the woman's lawyer, then the two negotiate a deal to secure the woman's silence. The people would be paid $130,000 for the rights to her story, according to the statement of facts. Trump allegedly tells Cohen to delay making the payment to the second woman as long as possible. If he is able to delay making the payment until after the election, they could avoid paying altogether. Trump allegedly says, per prosecutors claim emails and text messages between both lawyers and the AMI editor-in-chief, so they attempted to delay making the payment for as long as possible, according to the statement of facts. Ultimately, Trump agrees to the payoff and directs Cohen to proceed. Shortly after, this is October 26, 2016, shortly after speaking with Trump over the phone, Cohen opens a bank account in Manhattan in the name of a shell company that he had created to effectuate the payment, according to the statement of facts. Cohen then transfers $131,000 from his personal home equity line of credit into the account, according to court documents. This is October 27th, the day after that shell company was opened. In 2016, Cohen then transfers the $130,000 to a lawyer representing the second woman accusing Trump of having a sexual encounter with her while he was married to suppress her story, according to court documents. By November 8th of 2016, AMI releases the doorman. That's right as Trump wins the 2016 election. By January 2017, prosecutors allege that between Election Day and Inauguration Day, Trump meets privately with Pecker in Trump Tower in Manhattan, thanking him for handling the stories of the doorman and the first woman, according to the statement of facts. Trump invites Pecker to the inauguration, according to the statement of facts. By January 2017, Trump arranges to reimburse Cohen for the payoff he made on his behalf shortly after being elected president, according all this information according to the statement of facts. I do believe so. Cohen meets with Weisselberg to discuss how he would be reimbursed, with Weisselberg asking Cohen to bring a copy of a bank statement for the shell company account showing the $130,000 payment, according to the statement of facts. I want to note this is Alan Weisselberg, who we're talking about, the CFO at the time of the Trump organization. Weisselberg and Cohen then agreed to a total repayment of $420,000. That figure reflected double the $130,000 payment. Now there had been speculation here that $130,000 payment was so Michael Cohen would actually be making money, because you have to think that $130,000 would now be taxed. So that was in hopes that he would get paid here. And I believe we are fixing to see, maybe in just a moment here, President Trump walk in. We'll be waiting any moment for that, or has he? Let me check here. President Trump deciding not to talk to the press here. I want to show you this if we can go over to that. This was just a few seconds ago. His team walking through those doors. Trump walking right past, deciding ultimately not to talk today to the press. Watch here. Here he comes. I don't know if he waves. He waves, gives a nice fist. He ultimately deciding not to talk to the press today. Okay, we'll continue here. We're now on January of 2017. This is when they're arranging the reimbursement to Cohen, allegedly, according to the statement of facts. Weisselberg and Cohen then agreed to a total repayment of an amount of $420,000. That figure reflected double the $130,000 payment. Again, speculation that this was because of taxes. And the $50,000, now known as the Red Finch payment, which Michael Cohen testified on the stand that he stole $30,000 of it and only paid $20,000 to Red Finch from the trunk org there. That was the $50,000 reimbursement for another expense in addition to a $60,000 year in bonus. So Cohen could characterize the payment as income on his tax return instead of a reimbursement, according to the statement of facts. Last thing here, Trump, Weisselberg, and Cohen agreed the lawyer would be paid the $420,000 through 12 monthly payments of $35,000 over the course of 2017. According to court documents, Cohen was to send an invoice to the Trump org falsely requesting a payment of $35,000 for legal services rendered. Cohen does not have a retainer agreement with the Trump or the Trump organization, according to prosecutors. So that kind of just develops a little bit of this case here. Let me get the paper back in order. That just develops a little bit of the case here. Now I'm seeing reporters walk back into that courtroom there. So we will be watching that feed there on your screen beside me. Should be all throughout the day. We apologize for that lagginess if there is any. It's really hard to fix. I've been working with it for months now, trying to fix lagginess when it comes to different things of that nature. So we do have that link. Set this over here because I've already read it. Okay. Let me go here. One moment. Let me get spec set up here. So, I mean, that's a lot, but I think it fills you in kind of where we are today. I want to just skip the release of the indictment and arraignment where Mr. Trump pleaded not guilty, which is why we are in this trial. But coming up, I'll read you a story by Axios titled Trump's New York Criminal Trial. Who has testified and who hasn't? That's all when we return. Stand by here. But that is all when we return here. If I can go back to... If you'll just give me one moment here to get things set in stone here. When we return to that Axios story, I will read that to you. Okay, when we return, that Axios story, you're watching Brooklyn News' Trump in the Trial coverage. goes through everything in this trial. Happening right now in courtroom 1530, Trump has taken a seat at the defense table alongside his legal team. In his entourage today, we have Don Trump Jr., his son, Boris Epstein. I'm also learning Jason Miller and Stephen Chung have joined him today. Again, I also believe we saw Laura Trump in that group walking into the courtroom earlier. I'm not sure if she's what's going on there. We'll wait to see if we have any updates there. But now to this Axios story titled Trump's New York criminal. Trump's. There we go. I believe this is it. Yeah. Okay. Titled Trump's New York criminal trial: Who has testified and who hasn't? Here we go. Let's read it. Okay. Michael Cohen, former President Trump's one-time fixer, finished testifying on Monday in Trump's New York criminal hush money trial before prosecutors rested their case, allowing the defense to call its first witness. Now, we do know this story was earlier. The defense has now called both of its witnesses, and that is actually in the story. Why it matters: prosecutors alleged a 34 felony count of falsifying business records against Trump pertained to his involvement in hush money payments orchestrated by Cohen to buy adult film actress Stormy Daniels' silence about a claimed affair with Trump before the 2016 election. Trump has denied wrongdoing in the case brought by Manhattan District Attorney Alvin Bragg. State of play: Cohen was a star witness in this case, as he organized and personally paid the $130,000 in hush money, eventually paid to Daniels. Prosecutors alleged that reimbursement payments to Cohen were falsified by Trump to appear as legal expenses. In addition to Cohen, the jury has also heard from Daniels, who detailed her alleged sexual affair with Trump in 2006. That encounter lies at the heart of the prosecutor's case. The prosecution argued during opening arguments in late April that the alleged falsified business records and other actions amounted to Trump interfering with the 2016 presidential election. Now, to catch you up quick here, during his testimony, Cohen said Trump had approved of the hush money scheme and was aware that the reimbursement payment should be marked as legal costs. He said the scheme stemmed from Trump's worry that Daniels' story could damage his 2016 presidential campaign while it was still reeling from the release of the Access Hollywood tape. During cross-examination, Trump's legal team sought to undercut Cohen's credibility as a witness, attempting to present him as a deceitful and seeking. Now, who has testified now, though? The whole reason of the story here: Hope Hicks, a former top aide in the Trump White House. Hicks took the stand during the second week of testimony and detailed how the infamous Access Hollywood tape set off a wave of panic in Trump's campaign. She said Trump told her to deny Daniels' allegations and had claimed that Cohen paid Daniels, quote, out of goodness of his heart, which she said did not correspond with her understanding of Cohen's character. Now to David Pecker, who also testified here, the trial's first witness, the former National Enquirer publisher, which just before the break we went over here. David Pecker, publisher, who, according to the statement of facts, had this, what the catch and kill scheme means, to find the story that may be bad to Trump and pay the person either for exclusive access or just, get rid of that story there. And post stories that were particularly bad about, at the time in 2016, Trump's opponents, or this would actually be 2015, yeah, and 2016, I do believe. He testified, the trial's first witness here, David Pecker, the former National Enquirer publisher and a longtime friend of the former president, testified for multiple days. One moment here. Okay. Pecker detailed how he would suppress stories critical of Trump, including other alleged affair with Playboy model Karen McDougal, who was the recipient of the second hush money payment alleged by prosecutors. Pecker said he would carry out these, quote, catch and kill schemes in coordination with Trump, buying exclusive life story rights from people and then burying their stories. Pecker admitted that he knew that the $150,000 hush money payment to McDougal to buy her life story rights from people and then burying their stories. Pecker admitted that he knew that the $150,000 hush money payment to McDougal to buy her life story rights and essentially silence her likely went against campaign finance laws because it was coordinated with Trump's political campaign. Now, Rhonda Graff also testifying after Pecker, Trump's former assistant, took the stand. Graff, who maintained Trump's contact list, testified that he had contacted information. He had contact information from McDougal and Daniels. Prosecutors used Graff's testimony to authenticate Trump's contact list and entries for Daniels and McDougal in the Trump Organization's mail and calendar software. I'm sorry, here, guys, I'm one mode here. I believe I'm gonna have to do it over here. Oh, did it change here? Okay, okay. That's going to be the end of her testimony, I do believe. Then we're going to go to Gary Farrell, a former senior managing director at First Republic Bank, was a key document witness as he saw the opening of Essential Consultants, an LLC allegedly used by Cohen to distribute payments in an alleged hush money scheme in the lead up to the 2016 election. Farrell testified that Cohen, who received a three-year prison sentence after pleading guilty to campaign finance violations and other federal crimes, that claimed the LLC was for real estate consulting and marked on an application that they would not be associated with political fundraising or a political action committee. Now we move on to Philip Thompson. After Browning came Thompson, who works for a court reporting company that was involved in recording and transcribing Trump's October 2022 a deposition in one of E. Jean Carroll's defamation cases against him. Parts of the deposition were shown in the trial, including one clip of Trump verifying that it was him speaking on the Access Hollywood tape. Keith Davidson then testified. Davidson, a Beverly Hills lawyer, had negotiated the Daniels hush money payment central to the case, as well as McDougal's contract with the National Enquirer's parent company. During his testimony, Davidson admitted that he knew that McDougal's deal would help Trump's candidacy and that it was his understanding that the release of the Access Hollywood tape was the driving force behind the deal to bury Daniel's story. Then we move on to Jeff McConney, who testified. In his testimony, McConney, the former corporate controller at the Trump Organization, described how Cohen was reimbursed for the payments to Daniels. McConney testified that the reimbursement payments to Cohen began in 2017 after Trump was sworn into office and were not reviewed by the Trump Organization's legal department. He said at least 11 of the payments came directly from Trump's personal bank account, and these checks were sent directly to the White House for Trump to sign. Now we move on to Stormy Daniels' testimony here. We'll check for updates here in the courtroom here. Stormy Daniels, in addition to detailing the alleged affair, Daniel recounted being physically threatened in 2011 in a parking lot after she granted a tell-all interview with the magazine. Daniels also renounced a 2018 statement in which she denied the alleged affair. She said on the witness stand that she did not want to sign the statement because it wasn't true. Robert Costello then testified the defendant's it would actually be the defendant's second witness, as they did have one of their paralegals testify first. He testified just to how much information the defense had to go through, I do believe so. The defense's witness was Costello, a lawyer who once advised Cohen through his testimony, quickly went off the rails. I believe that. I think that's a good way to explain it. The judge admonished Costello for his reactions to rulings while on the stand and briefly cleared the courtroom during his testimony. Okay, I do believe that's all we have on that story. Happening right now in the courtroom. Just stand by with here. Marshawn is now on the bench. The parties then introduced themselves. I believe you both presented with the proposed verdict form, just what Sean says, and you initialized it. Okay. Steinglass is now raising an issue, a minor omission on the verdict sheet, talking about the 34th count. He says, for it to be consistent with the others, it should read bearing check number 003006. Rashawn thanks him and brings in the jury. Okay, just fixing there on the jury instructions. The jury is now filing in. Marshawn greets the juries and begins to charge them. Good morning. I will now instruct you on the law. Marshawn begins saying they'll start with general law, which applies to this and all criminal cases, then charges specific to this case, the guidance on deliberations. According to Judge Marshawn, the jury will not receive copies of the instructions. Justice Marshawn has estimated that this will take 1 hour. His reference to evidence or not to refer evidence should have no bearing. In fact, nothing he said in court of this trial should give the impression that he has an option about this case. He is starting with the meaning of a fair juror, a person who will be impartial and decide without bias or prejudice based on, or example, race, gender, sexual orientation. He says a fair juror will be mindful of stereotypes and attitudes and shouldn't let that affect their verdict. He tells the jurors that you are the. I'm sorry. He tells the jurors that you are the judges of the facts. He says to the jury, and you will decide if the defendant is guilty or not guilty. He reminds them of their promise to be fair or impartial. Okay. So many more updates right after this short break here on Trump in the Courtroom coverage right here on Brooklyn News. I'm Jackson Mitchell. Oh, I believe not. Same thing again here. Hold up. Okay. So much more Trump in the courtroom coverage right after this short break. You're watching Brooklyn News' special coverage on this Wednesday. Deliberations expected to begin in nearly an hour. Stand by here. Welcome back to Brooklyn News as Trump on in the courtroom coverage. Live updates are now coming from inside that courtroom where Judge Juan Merchan is delivering jury instructions to the jury. Now, happening right now, he says, sorry, I was just reading some of this throughout the break. He's right now he's delivering jury instructions. Just before this, he's saying basically you cannot use any biases against judging this case. He says he's going to be doing general criminal law, and then he's going to move on to the exact law in this case. And what jury instructions do they I've heard it explained as a roadmap, and I truly do agree with that. It guides the jury as to what they're judging, what they're going to be judging for, and kind of the definitions of the law here. So he says, justice requires no less. He says, concluding the portion warning against bias, he continues, you will decide this case fairly on the evidence and the law as it relates to the defendant here on trial, setting aside personal options or bias against the defendants. Merchan reminds them they may not render judgment related to speculation about sentence or punishment. Justice Merchan is now evaluating the evidence. You can consider any fact that is proven and any inference drawn from those facts. Justice Merchan then explains what an inference is, providing the classic example of what an inference that it rained while you slept if you wake up and see the people with umbrellas and in raincoats. Justice Merchan explains that some exhibits were admitted into evidence for a limited purpose only. He reminds the jurors of some of the limiting instruction he's providing during the trial. So we do possibly have kind of this long, drawn-out, and boring process ahead. We're talking about deliberations. We're not talking about jury instructions. Jury instructions are very key to everything going on here. Along the boring process ahead as deliberations do begin, reporters are not allowed to leave that courtroom once the jury does leave and go into the deliberation room where they will conversate and come together on a decision. Will a decision come today? That's something we don't know. Will it come later in the week? Also very possible. But I'm going to cut myself off when we see something new here, of course, and what may happen. We'll do our best there. Sorry guys, I'm just reading through some of this stuff here. We also may see public access come to this, to the jury instructions, and we'll read that to you when we get them. Okay, now we are talking about, he's talking about some evidence here. We're just kind of putting out some rules on it. He says, first, AMI's non-prosecution agreement and conciliation agreement with the Federal Election Commission, it's to be used to evaluate David Pecker's credibility and some of the surrounding circumstances, but it's not evidence of Trump's guilt or innocence. Similarly, yeah, I can't do it. Similarly, yeah, no. One of these days I'll be able to do the ARLY. No, don't get me started with that. But you know what I'm trying to say here. Cohen's FEC investigation, his attorney's responses to that investigation, and his guilt pleas relate to campaign finance are to be used only to assess Cohen's credibility as a witness. So he's talking about the Cohen's FEC investigation. Only to be used to determine credibility with Cohen. Let me recap any new information coming in here. There are other exhibits that are contained hearsay and were not admitted for the truth of the matter asserted. For example, the National Enquirer headlines were admitted to show that the articles were published, not that the headlines were true. Okay, we're already reading all about that and talking all about that throughout this whole entire thing. We are going to take another break when we return. Live updates from that courtroom. What is going on? as jury instructions do continue, expected to take nearly an hour. I'm Jackson Mitchell, and this has been Brooklyn News and special coverage of Trump at the courtroom. So much more when we return. And welcome back to Brooklyn News' coverage of Trump in the courtroom. I'm Jackson Mitchell. This is our special coverage here on Brooklyn News. Okay. Inside the courtroom right now, jury instructions are happening right now. And those are extremely important. They provide definitions, the law, etc. As I said earlier, it's explained as a roadmap here. As the jurors go into deliberations in nearly, about 40 minutes, 45 minutes maybe. I want to name 3 of the possible things that can happen with the jury when they make their final decisions. They can make a unanimous decision, meaning they all are agreeing in a guilty favor. All 12 jurors decide Trump is guilty. 2, a hung jury, meaning there is at least one juror that may say he's not guilty or that he's guilty different than the rest, or that there's multiple and none of them can agree with each other. And then we have an acquittal, meaning all ruled not guilty. We will be watching for all of those. Now, also to note, this could jury deliberations can take hours, days, weeks, or even months. We don't know how long it's going to take. Updates are coming in right now. I want to go back over to that. Justice Rashad is telling jurors that the people have the burden of proof. They must prove the charges beyond reasonable doubt. The defendant is not required to prove that he is not guilty. Basically saying that because, in cases like this, the prosecution has to prove that the defendant here is guilty without reasonable doubt, while the defendants have to just put reasonable doubt on the prosecution's case. So basically, reasonable doubt means that the people must prove beyond a reasonable doubt every element of crime. If the people fail to satisfy this burden, you must find the defendant not guilty. What does proof beyond reasonable doubt mean? The law does not require the people to prove guilty beyond all doubt, but the proof must be stronger than the doubt. So let me take a few notes here, kind of what kind of in these instructions, what they were kind of talking about here. Okay. If the people fail to satisfy this burden of proof, you must find the defendant guilty. Merchan tells the jury, and vice versa. So again, if the people fail to satisfy this burden of proof that with reasonable doubt the defendant is guilty, fails to say with reasonable doubt that this defendant is guilty, you must find the defendant guilty. I'm sorry, hold up here. I'm sorry, I read that all wrong. If the people fail to satisfy this burden of proof, you must find the defendant guilty, and vice versa, Merchan says. Now we are moving on to credibility of witnesses. The jurors must decide whether a witness told the truth. If you find a witness testified falsely, you may disregard some or all of that testimony here. Now, something to also note here is they go into jury deliberations soon here, as soon as they're done with these instructions. They are able to request different evidence and different things of that nature. So, if they want to document, if they want to review something, maybe to see if the, things such as Cohen's credibility, because the defense really went after that in their closing arguments. And I believe we also want to go to, let me see here. Okay, yes. Okay, in just a moment here. Let me check if we have any more updates. We're going to take a quick break, and then we'll summarize the closing arguments that the defense and the prosecution made when we come back here. It does not appear we have any more updates right now. The thing they're talking about right now is credibility of witnesses. You're watching Brooklyn News' coverage of Trump in the courtroom. We will be right back. Welcome back to Brooklyn News' coverage of Trump in the courtroom. Happening right now, Judge Juan Merchan talking about credibility to witnesses and how the jury may decide that, saying that is their own choice, saying you may consider whether a witness had or did have a motive to lie, and you may consider whether that motive affected the testimony's truthfulness, the judge says. You may consider whether a witness hopes for or expects to receive a benefit from testifying or from a certain outcome. And yesterday, the defense and the prosecution made their final arguments. The defense, only about 3 hours. The prosecution, 5+ hours of closing arguments. Happening, we'll go first to the defense here, because that's who started first here. So I'll read this story here from the New York Times, titled What Donald Trump's Lawyer Said in His Closing Argument, by Matthew. Okay, and we'll be watching updates from inside that courtroom for them to come in any moment now. A defense lawyer for Donald Trump said Tuesday in the closing argument of his criminal hush money trial that the former president was not only innocent but also a victim of extortion. Of extortion by liars seeking his demise. The person, in fact, at fault was Michael Cohen, his former fixer and a key witness for prosecutors in the first criminal case against the former American president, said Todd Blanche, the lawyer who delivered the closing argument. During a sometimes meandering 3-hour closing presentation, Mr. Blanche declared that Mr. Cohen lied directly to the jury and that Mr. Trump did not know about Mr. Cohen's hush money payment to Stormy Daniels, an adult film star who said she had sex with the former president. Mr. Blanche used sports metaphors and a rambling top 10 list in an effort to convince the 12 jurors of Mr. Trump's innocence, repeatedly taking aim at Mr. Cohen. Quote, he's literally like the MVP of liars, Mr. Blanche told the jury. Later, Mr. Blanche tried a different sports-inspired description, saying, quote, Michael Cohen is the GOAT, he said, short for, quote, greatest liar of all time. Mr. Trump faces 34 felony counts of falsifying business records that stem from the $130,000 payment by Michael Cohen to Ms. Daniels, who had been considering going public in the days before the 2016 election with her account of a sexual encounter a decade before. Prosecutors have argued that Mr. Trump falsified records when he repaid Mr. Cohen in 2017 for that deal, deliberately mislabeling reimbursements as, quote, legal expenses to conceal their true purpose. The financial documents were proposed by the Trump Organization, the former president's family business. Mr. Blanche told jurors Tuesday that the prosecution had not met its burden of proof, adding that the evidence, quote, should leave you wanting more, end quote. He reminded the jury that only Mr. Cohen had testified that Trump knew everything about the hush money payments of Ms. Daniels. Quote, you cannot convict President Trump on any crime beyond a reasonable doubt on the words of Michael Cohen, Mr. Blanche said. Mr. Blanche said that Mr. Cohen had an axe to grind because he did not appreciate what Mr. Trump, quote, did and did not do for him after taking office. Mr. Blanche said that there was, quote, not a shred of evidence that Mr. Trump had plotted to falsify records related to reimbursing Mr. Cohen. He also said that Mr. Cohen had a legitimate legal retainer with Mr. Trump as his personal lawyer. The records were not false, Mr. Blanche claimed, because of an oral retainer agreement. Prosecutors have said that no such agreement existed. Several times, Mr. Blanche said that Mr. Trump did not have sex with Ms. Daniels. He wrapped up the closing argument by listing 10 reasons that jurors should have reasonable doubt Mr. Trump's guilt. The final reason was Mr. Cohen, whom he called, quote, the human embodiment of reasonable doubt. So that was the defense's closing argument there. So very interesting happening right now inside that courtroom. Okay, so happening at one point, just as Rashawn reads these instructions, a loud noise momentarily erupts from the phone of someone in the front row, where Don Jr. and Alina Habba are seated, and it sounds like a news broadcast, according to a reporter inside that courtroom. Don Jr. appears to laugh a little bit as he looks over at Alina Habba. Back to the jury instructions. Under our law, Michael Cohen is an accomplice. He gives a variation of the party's proposed accomplice as a matter of law. Okay, and we do have that for you guys to read. I believe we can pull it up over here. So just stand by with me. We can pull up the joint accomplice as a matter of law here. Okay, I'll read this off to you guys. One moment here. This is what they're talking about inside the courtroom right now. This is the proposed instruction on accomplice as a matter of law. People versus Trump, indictment number 71543-23. People's disputed request. Defense disputed request. Under our law, Michael Cohen is an accomplice because there is evidence that he participated in a crime, participated in and was convicted of 2 crimes based upon conduct involved in the allegations here against the defendant. Our law is especially concerned about the testimony of an accomplice who implicates another law in the commission of a crime, particularly when the accomplice has received, expects, or hopes for a benefit in return for his testimony. Therefore, our law provides that a defendant may not be convicted of any crime upon testimony of an accomplice unless it's supported by corroborative evidence tending to connect the defendant with the commission of that crime. In other words, even if you find testimony of the accomplice Cohen to be believable, you may not convict the defendant solely upon that testimony unless you also find it was corroborated by other evidence tending to connect the defendant with the commission of the crime. Okay, I think that's a good read there. Basically saying you cannot convict Donald Trump solely on the evidence, solely on the testimony, from Michael Cohen. Okay, happening right now inside that courtroom. He is now instructing the jury on the law applicable to the charged offense. Mershon says that charge is falsification of business records in the first degree. He starts with an instruction on accessorial liability, the idea that a person can be held liable for the criminal acts of another, provided that one, he solicited, requested, commanded, or intentionally aided that person to engage in criminal conduct, and 2, he did so with the requisite state of mind required for the commission of that defense. And give me just a moment. Let me go to the docket here. I believe they've added this on the docket now, so we're able to kind of view a little bit of what that says. Okay, so now Justice Mershon is explaining the elements of falsifying business records in the first degree. We have the parties' proposed instructions, I do believe so, of what that may be here. So if you'll... Okay, give me just a second, guys. Okay, here we do have that. Here's the parties' proposed instruction on falsifying business records in the first degree. This basically is defining it, the definition here of, and I believe we can show that to you. Nope, hold up here. Okay. And while that goes there, okay, so now we're talking right now on what falsification of business records. basically defining what falsification of business records mean. He says he starts with an instruction on accessorial liability, the idea that a person can be held liable for the criminal acts of another, provided that one he solicited, requested, commanded, or intentionally aided that person to engage in the criminal conduct, and he did so with a requisite state of mind required for the commission of that offense. Okay. Here's that on your screen momentarily. Here is it now. Okay, there you go. You can see this raw before it gets put in any of our systems here. The first count is falsifying business records in the first degree as it pertains to an invoice from Michael Cohen, dated February 14, 2017, marked as a record under the Donald J. Trump Revocable Trust, and kept or maintained by the Trump Organization. Under our law, a person is guilty of falsifying business records in the first degree when with intent to defraud. That includes an intent to commit another crime or aid or conceal the commission thereof. That person makes or causes a false entry in the business records of an enterprise. And then it goes on to define what those words are there. You'll see, zoom in there. It goes on to kind of define what an enterprise of business records and what intent is. Okay, so you see those two highlighted lines there under intent. I'll read the definition here. And the judge has omitted that, saying something else here. I'll say intent means conscious, objective, or purpose. Does a person act with intent to defraud when his or her conscious, objective, or purpose is to do so lead into error or disadvantage? Instruction requested by the defense, reasonably foreseeable language requested by the prosecution. And I believe he has just omitted those two lines there and just gotten rid of it. Now, I want to read something about the other crime here. If we can, I believe it should be in here somewhere. Okay, here we go. I'll read this here for you guys. Intent to commit or conceal another crime. Let me zoom out just a little bit here. Okay. For the count of falsifying business records in the first degree, the intent to defraud must include an intent to commit another crime or to aid or conceal the commission thereof. Under our law, although the people must prove an intent to commit another crime or to aid or conceal the commission thereof, they need not prove that the other crime was in fact committed, aid, or concealed. In addition, there is no requirement that a defendant intend to conceal or aid the commission of his own crime. Instead, a person can commit the crime of falsifying business records in the first degree by having the intent to cover up or aid the crime committed by somebody else. Okay. Now, way before we got into all these documents that are being released right now, we were talking about the defense and the prosecution's closing arguments. We are going to take a quick break, and when we come back, we are going to have so much more on the prosecution's closing arguments by Assistant District Attorney Joshua Steinglass that lasted over 5 hours. We'll be right back right here on our coverage of Trump in the courtroom. controversial, happening right now inside the courtroom. The jury is being instructed by Judge Juan Merchan. These are instructions very important to the decision they are going to make that determines the fate of the former president of the United States, whether he is guilty or not guilty. The jury instructions defining clear definitions on what the law is, both agreed to by the defense and the prosecution. Happening right now in that courtroom, Judge Juan Merchan says, you may consider the following. 1. Violations of the Federal Election Commission Act. Falsification. 2. Falsification of other business records. 3. Tax fraud. He begins with federal election. An expediture made in concert with, at the suggestion of, it's really confusing. Let's go back to this 1, 2, 3. 1. Violations of Federal Election Commission Act or FECA. 2. Falsification of other business records. 3. Tax fraud. I believe we also have what they were just reading a moment ago, or they could still be reading that now. That is going to be the proposed instruction on election law. I believe that's talking about the Federal Election Commission Act violation. Stand by here. Yes, that's what this is talking about. If we can. Okay, I believe we have it now up on your screen, able to show it to you. There we go. You're seeing this before we actually download it and put it into our system. I want to show you something here. Usually it would look more like this, and we'd actually be able to show it to you guys. This is before we put it into our system here. Actually, I may be able to do that as we're waiting here, but let me see if I can do that right now. Stand by. So here's what they were reading at least just a moment ago here on your screen in just a second. I'm sure enough this is the election law proposed. There we go, it's on your screen right now. Okay, this is the election law. It says, the people allege that the other crime the defendant intended to commit, aid, or conceal is a violation of New York election law section 17-152. Section 17-152 of the New York election law provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means in which conspiracy is acted upon by one or more parties thereto shall be guilty of conspiracy to promote or prevent an election. So that is the other crime. Okay, I want to talk about something. They're saying this is what the falsification of business records was done with intent to conceal another crime. That other crime being the violation of New York election law 17-152, which provides that any two or more persons, and I'll go back to reading this document here, provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means in which conspiracy is acted upon by one or more of the parties thereto shall be guilty of conspiracy to promote or prevent an election. Okay, the first theory there that we were just talking about was Federal Election Commission Act. We are now into the second theory, the falsification of business records. They may consider 1. Bank records, association with Cohen's account for resolution, plus Essential Consultants LLC. 2. Bank records associated with Cohen's wire to Davidson. 3. The invoices from Advisory Services, Inc. Advisory Services, Inc. To RC there, okay. Okay, we are going to take a short break, and you guys were just viewing that PDF there from some of the stuff they're reading about election law. We'll be right back after this. And welcome back to Brooklyn News' coverage of Trump in the courtroom. I'm Jackson Mitchell. Thank you for choosing us as your source for the information in all of this. Right now, inside that courtroom, jury instructions going on as the jury is instructed by Judge Juan Merchan. They have moved on now to tax fraud. Judge Juan Merchan saying it's unlawful for any person to willfully state or submit false documents to tax authorities, even if it does not result in underpayment of taxes, Merchan says. And here, let me write some of this down here. And then we also need to talk about the prosecution's final argument here. I have that. We're going to get to it eventually. Let's go back up here. So Merchan is explaining the underlying law. He just explains, applies to each count in the indictment, which all relate to discrete records, invoices, check, ledger system vouchers. Merchan is now slowly, according to court reporters, reading through all of the counts. And the jury is also able to the jury is also able to go through these during deliberations. Merchan is explaining the precise records underlying each count, Cohen's invoices, the checks signed by Trump's or other Trump ledger entries. Lather, rinse, repeat is how it's being explained in the courtroom. For each count in the corresponding document. So far, we have seen in these jury instructions talking about, Judge Merchan talked about biases, evidence, what it can be used for, just clarifying some of the evidence and what it was used for, what it cannot be used for. Reasonable doubt. Has the defense proved reasonable doubt against the prosecution, and has the prosecution proved reasonable doubt that the defendant here is guilty. Violation of Federal Election Commission Act, falsification of other business records was also talked about, tax fraud, and now he is reading all 34 counts. I don't want to go to the final argument from the prosecution. I read the defense earlier, but then we got distracted. All of it really got interesting over there in the courtroom. I'll now read you to all the prosecutions. It was more than 5 hours, so now I'll read it to you here. Over more than 5 hours on Tuesday, a Manhattan prosecutor made his final case to the jury in Donald Trump's criminal hush money trial that the former president has orchestrated a, quote, conspiracy and a cover-up, end quote, to help him win the 2016 election. The prosecutor, Joshua Steinglass, argued that 20 witnesses called to the stand and evidence presented during 6 weeks of testimony had shown that Mr. Trump was guilty of 34 felony counts of falsifying business records. The charges stem from his repayment made on the eve of counts of falsifying business records. The charges, made on the eve of the 2016 election of hush money that silenced the porn star's account of a sexual encounter a decade earlier. Mr. Steinglass wove a sweeping story of how Mr. Trump will help the sorry, I'm going to find myself here. Okay, Mr. Steinglass wove a sweeping story of how Mr. Trump will help from the National Enquirer and his former fixer, Michael Cohen, among others, sought to bury negative news stories about Mr. Trump in the days and months before the election. One effort included the catch and kill operation to buy the silence of Stormy Daniels, the porn star, which Mr. Steinglass said kept the American public from knowing about her account when they voted. Quote, this scheme cooked up by these men at this time could very well be what got President Trump elected, Mr. Steinglass said. Quote, this was over election fraud, an act in furtherance of the conspiracy to promote Mr. Trump's election by unlawful means. A deal with Ms. Daniels took on extra urgency, he said, following the leak in October 2016 of an, quote, Access Hollywood tape that captured Mr. Trump bragging about grabbing women's genitals. Mr. Steinglass started his closing argument by countering the statements by Mr. Trump's lawyer, Todd Blanche, earlier that in the day. He said that the Trump team's closing argument, which claimed that Mr. Trump was a victim of extortion, did not change the underlying facts of the case. And Mr. Steinglass noted, extortion is not an offense for falsifying business records. Mr. Steinglass acknowledged to the jurors that some of the witnesses had biases. Both Mr. Cohen and Ms. Daniels have talked publicly about wanting to see Mr. Trump convicted, and Mr. Cohen admitted on the stand that he stole money from the Trump Organization, but he said their testimony was credible and often corroborated by others who took the stand. Quote, I'm not asking for you to feel bad about Mr. Cohen, Mr. Steinglass told the jury. He made his bed. At the end of the marathon day, just before 8 p.m. or 7 p.m. Central Time, it was actually 6:57 exactly that the prosecution finished their closing arguments there. Steinglass said that while the former president is a former president, the law applies to him the same as it does to anyone else. A very long, some people would say it was kind of boring and long, but we'll have to see if it was needed for the 5 hours of closing arguments, what the jury may decide when it comes to the fate of the former president. Happening right now inside that courtroom. Stand by here. We were on count 32 now. That was 2 minutes ago. Rashawn is now reading about what kind of this means here, and I'll pull up what we were just talking about earlier if I can on the screen for you guys. Just give me just a second here. It's loading into our system right now, and I'll pull it up for you guys. And this is basically defining the definition of first-degree falsifying business records. There we go. Okay. falsifying business records in the first degree. The first count is falsifying business records in the first degree, and then it goes on to explain that. And even if you go into the next pages here, it even will show you the exact definitions of some of the things defined here. Okay. He is now reading about the intent, but he excludes the language. He's excluding the language, including the government or voting public. So right here, I'll read this to you. In order to prove an intent to defraud the people, need not to prove the defendant acted with intent to defraud any particular person or entry, a general intent to defraud a person or entity, including the government or voting public. So he cut that off there at the end of that line there. It then goes on to continue saying intent to defraud is also not constricted to an intent to deprive another of property of money. In fact, intent to defraud can extend beyond economic concerns. Now, what we're also talking about here is we only have the draft version, so we are able to show you guys here. We only have the draft version, so court reporters are just explaining here what may be excluded from what we are seeing. But a lot of documents here. I'll show you guys for just a second here. A lot of documents that we are watching and have pulled up for you guys, and will continue to do so. You're watching Trump in the Courtroom. It's Wednesday. Deliberations beginning right after this, right after really any moment now, as it appears that Judge Juan Merchan is coming to an end here in reading the charges. We'll be right back with that on Brooklyn News. Coverage here on Brooklyn News. I'm Jackson Mitchell. Thanks for tuning in. Okay, we are still in this part where Judge Merchan is reading the definitions of the law. Right now, he is reading the instruction on the quote unlawful mean under 17-152. He has omitted this huge paragraph here. Requested by the defense, saying that 17-152, which is the election law here, requires the proof that the goal of the conspiracy was to promote the election of a person by unlawful means. Okay, and now he has moved on to reading the instructions in the Federal Election Campaign Act. Notably, he includes the willfully language requested by the defense. He is omitting the sentence requested by the defense regarding limits on a candidate using personal funds in 2015 and 2016. I'll read. Actually, we may have this somewhere in here. Let me check. it's going to be. I don't think we have the proposed instruction on the Federal Election Commission Act here. Yeah, we do not. Is it over here? Have that here in just a second. Okay, we have that for you guys now. Okay, here is what we're talking about right here. Where it talks about the people's disputed request under the Federal Election Campaign Act. It is unlawful for an individual to willfully. They keep that language in there. That was requested by the defense, I believe. So, to willfully make a contribution to any candidate with respect to any election for federal office, including the office of President of the United States, which exceeds a certain limit. In 2015 and 2016, that limit was $2,700. It is also unlawful under the Federal Election Campaign Act for any corporation to willfully make a contribution of any amount to a candidate or candidate's campaign in connection with any federal election, or for any person to cause such a corporate contribution. For purposes of these Anyways, an expenditure made in cooperation, consultation, or concert with or at any or at the request or suggestion of a candidate or his agent shall be considered to be a contribution to such candidate. He cuts out this line here saying, quote, in 2015 and 2016, there was no limit on a candidate's ability to contribute personal funds to his or her campaign. He cuts out that line there. Okay, a reporter says it is becoming abruptly clear to me that Justice Merchan's 1 hour estimate, including reading the jury instructions in full for 30 minutes, then again for another 30 minutes. Basically because there's 34 different counts, so he has to read each and every one of those counts and then go through that again here. So there is that. You're watching Trump in the courtroom. It is Wednesday coverage here, though. We'll be right back. Right now, Rashawn clearing his throat after such long talking there, explaining the difference between motive and intent. Intent means conscious, objective, or purpose, whereas motive is the reason why a person chooses to engage in criminal conduct. Intent is a required element here, but motive is not. Speaking on the intent to conceal another crime, we do have that document. This one right here. It's going to be talking about the intent to conceal another crime. That other crime being Election Law 17-152 in the state of New York. Some jurors are taking notes, Mershon says, and should only aid your memory, not take precedence over the evidence, and you must not be influenced by notes that other jurors have taken. Is that if there's a discrepancy between notes and testimony, you must ask for relevant testimony readback. And I will note, according to a court reporter earlier, there was a large amount of files being brought in that happened. And there's inside the courtroom right now, or right outside that courtroom, but there was a large amount of papers. There were everything. That was everything. So, everything from this whole entire trial here. And you can see all these documents that we're watching and waiting. And I noticed that's one had the black background. I don't know. Don't know how that all works. I just had to put the PDF file into the system here and then get it to go. He says, you may see exhibits entered into evidence on request, just as Mershon says. You may also request to hear testimony read back to you. Under our law, the first person selected is the foreperson, though that person's opinions nor vote are more important than others. That person's duty is to sign any written note from the jury, though agreeing with the note is not required to sign it, Mershon says. When you reach a verdict, guilty or not guilty, you will be asked to come back to court for the verdict. The foreperson will be asked to read the verdict, and the entire jury will be asked if that is their verdict. On request of the parties, each juror can be asked individually. It appears we are coming to the end of this. We've been live for an hour and 42 minutes, so we should be going to an end of it any moment now, because he's reading now, guilty or not guilty, what's going to happen during that, and instructions then. Okay, new update here. Judge Mershon turns to the verdict form. He explains that for each count, he has added language to identify the corresponding record, check, invoice, voucher related to that count. Okay, and so talking about the verdict sheet, which lists considerations to reach each possible verdict in addition to listing counts. Okay. So within that verdict sheet, which basically kind of has what counts they're going to be charged with, Judge Mershon says he has added listing counts and additional language to distinguish the counts. as in the invoice, the voucher, or the check. Finally, Marshawn says, as he gets to the end of his charge to the jury, there are a few rules you must follow during deliberations. Deliberate only while in the jury room. You must discuss the case only among yourselves. Must not permit anyone to discuss the case in your presence. Yourselves as in the jury. They all discuss it together. It's not just they just sit in a room and they're like, okay, guilty. They discuss it all together as what their options are going to be. The law requires that you communicate to me in writing during deliberations to ensure that there are no misunderstandings. If you have a question, you can write me a note and give it to a court officer. They said the plan is only to work until 3:30 p.m. today, and we will release the schedule as we approach that deadline if need be. 3:30 p.m. Central, 4:30 Eastern. So I believe we're getting to the final thing. I'm consistently reloading here to see if we have any new updates, and when we do, I'll read those to you. So right now we're just coming to an end to this, and he's saying, you can write notes to me, give it to a court officer, it'll get to me, etc. He says, quote, that excludes my construction of the law. Judge Rashan invites counsel to approach the bench. We'll see what happens there. But first, we're going to take a short break. You're watching Trump in the Courtroom coverage right here on Brooklyn News. I'm Jackson Mitchell. Brooklyn News' coverage of what looks to be deliberations beginning very, very soon, any moment now. Rashan concluding his instructions, talking about biases, how evidence can be used, and what it can decide, reasonable doubt from both the defense and the prosecution, witnesses' credibility, violation of the Federal Election Commissions Act, defining all of the law, including New York election laws, including the New York election law. They're looking to charge Trump. The prosecution is looking to charge Trump on the federal election of business records. The federal falsification of business records. Rather, he read all 34 counts, including the intent to conceal and then intent to influence the 2016 election is what I like to say, to just sum it all up together. And then he's explaining the selection process and how all that works. Now there was a sidebar going on, which is also referred to as kind of this. They just go up to the bench. They approach the bench and they're talking to the judge. They can object to certain things, such as they can object to maybe the way the tone was, the jury instructions were delivered, etc. They can, something may have happened, something may look wrong. They, inside that deliberation room where jurors are, I'm sure they're being taken very, very soon. Right now, one clarification, Rashawn notes that when the foreperson signs jury notes, the person should sign with their jury number, not their name, as this is an anonymous jury. A clarification, I figured there may be some type of new thing to come out of this, such as clarification of just some of the things he may have developed or set in his jury instructions, taking just over an hour here. Rashawn has sent the jury to begin deliberations. It's a little nerve-wracking now because they also may be giving some type of device or something so they can listen to the audio recordings. Judge Rashawn also saying that if all 12 jurors are not in the room, they must stop deliberating. Also, he said lunch will be provided to those jurors, and they're willing not to leave that room unless there may even be a restroom in that room unless they need to use the restroom or anything of that nature. Now they are to deliberate, ending at 4:30 p.m. today. So again, so much happening in the last hour and 51 minutes. That's how long we've been live. So much more to break down right after this break. What all happened in those jury instructions, what all was explained, and what happens now that the jury goes into deliberation. We'll be right back. Welcome back in here at Brooklyn News. Is Trump in the courtroom special coverage. Thank you all so much for joining me along all of this. I want to explain a few things here. What was discussed? I took a few notes as to what was discussed here. So he started out with kind of this biases. You cannot let your biases, maybe to the former president or to the prosecution, the DA's office, affect any type of your decision. He then went on to what evidence was used for, as in you can't use certain evidence to take down Michael Cohen, also clarifying that some of the AMI stories were put in just to clarify that those stories were actually written, nothing else. The reasonable doubt from the defense and the prosecution, the witnesses' credibility, violation of the Federal Election Commission Act, falsification of business records at earlier times, tax fraud. He ran all 34 counts, plus the intent to conceal basically the intent to commit another. For this to be an intent to commit, I should clarify, not conceal, is something totally different than commit here. He also explained the selection process here, so. The jury has now began, so as I was saying earlier, they could be given a tablet or an iPad or something of that nature that just has some of the information they may need on it. Following the sidebar, Justin Sean does tell the jurors there is a laptop containing the evidence introduced in the case. He'll need to show 2 jurors how to operate it. Now he has excused the 12 jurors to begin deliberations. Judge Merchan tells the 6 alternates that he needs to keep them around in case they are needed. They'll have to hand in their cell phones and electronic devices while they wait. The Justice Merchan announces that Juror 4 and Juror 6 volunteered to learn how to operate the laptop that contains the evidence in the case. And we also, I believe we do, and it may take us just a minute to pull up here, but we do have a graphic for the jury. I was going to use it more, but we have to change things around here. So let me. It takes just a minute to get there. It's slide 25. Or graphic 25. Oh. Here we go. So, if this is completely correct here, Juror 6 would be, Juror 4 would be a security engineer, and Juror 6 would be a software engineer. Okay. Maybe that's a good thing for them to volunteer to do this job here. We will have to see exactly what happens as deliberations do begin. You have been watching Brooklyn News' coverage of Trump in the courtroom. Our coverage right now is going to wrap up. We will be standing by all day today to see if they release or get to a decision today on whether the former president, whether this is an acquittal. I'll just read from my notes here whether this is an acquittal, a hung jury, or unanimous. We are waiting for it all and watching for it all. This could take days, this could take weeks, it could take months, it could take just hours today. We are watching it all. You have been watching Brooklyn News' special coverage of Trump in the courtroom. I'm Jackson Mitchell. We'll be standing by. Stick with us because we will be going right back live if they release, when they reach a decision, rather. Thanks for watching.